You have questions, we have answers. This is Jane Muller.
And this is Ken Muller. Welcome to our show. Today, Jane, we're going to continue on with the Q&A on the landlord-tenant. We didn't get to cover nearly as much as we wanted to the last show, so we have some more questions that the listeners have emailed us and texted us. So let's get to it so we can hopefully get through these questions. Then by next show, we're going to move on to a new topic.
Sure.
All right.
There's a lot to cover in the landlord and tenant.
Right. We could go on. You could devote a whole year to landlord-tenant because the laws are constantly changing and updating with the COVID and stuff. But I think we just want to get through some of the more basic questions and then move on. So one of the questions that often does come up and that people ask is what happens if the written lease expires and neither the landlord nor the tenant do anything? If you have a lease for a year, let's say it ends March 31st, 2022, but neither the landlord nor the tenant do anything, but the tenant continues to pay rent. What happens to that lease?
Month by month.
That's correct. In New Jersey, it automatically renews as a month-to-month lease. As long as the tenant continues to pay the rent, the tenant may stay there indefinitely.
I did have a story to share. And one day, I got a phone call from the landlord, very, very upset. And she said, I can't believe it. My tenant never give me notice. They're going to move out, blah, blah, blah. I said, hang on a minute. They break the lease? She said, no. The lease is end March 31st. And then they gave me the key they call me and they give me the key March 31st. So, and they want me to meet March 1st. I wasn't there yet that time, I guess. And they should give me a notice so I can find a new tenant. I said to her, unfortunately, that's a landlord, right? In the lease says 90 days, you have to let the tenant know whether you're going to continue rent or not. After receiving such notice, 30 days, which is 6 days before the lease end, the tenant have to tell you the intention. But if you forgot, you never give a tenant notice, the tenant the lease ends. So, in this case, the landlord lose the chance to promote the unit. So we just have to start after tenant move out because they only told landlord about the 1 or 2 days before, try to schedule a handover the key and the walkthrough, the handover the key and the lease. So I always remind the landlord, right, having a lease, having a rental property like have a part-time job here. You have to really put in now it's so easy. Now you have Google Calendar, you have all the calendars, reminder, you can send to yourself. But I'm talking about 10 years ago, that time, you have to have a diary. If you forgot to put it in, right, that's the issue. So just always make sure, put in your calendar 3 months. You have to 90 days before the lease end, contact your tenant. If you contact a little bit earlier, so their intention, so you can be prepared. Yes.
Right. And we do have to cover that in New Jersey, the tenants have every right to renew a lease as long as they're in good standing. Or in other words, the landlord cannot refuse to renew a lease unless there's what's called a good cause for doing so. And good cause is, again, a legal term. It could consist of the tenant fails to pay their rent or fails to pay their rent in a timely manner, or they're convicted of certain crimes or disorderly persons offenses. Those are all grounds for where the landlord can refuse to renew the lease, but then then they would still have to go through the legal process of the court to
once again consult your attorney when anything happens, right? That magnitude, you better just get professional help. Consult. We did had a few cases, which is the association wrote to the landlord, request landlord not renew the lease because tenant was had an issue with the neighborhood or something. So that's happened from time to time. At that time, I always advised the landlord. I said, ask association give you a letter. They can't just call you, tell you, because you can't just end the lease. You have to have a reasonable reason. So if association put in writing and say they request you not renew the lease, you can pass that on the tenant. So in that case, at least you protected yourself. Yes.
Right, and you may need more than just the warnings. Like with if there's certain offenses, there would have to be a conviction for that to be considered good cause for removal. So, but again, that's a case by case, and we don't want to get into all the nitty gritties. But you have to really consult with your landlord-tenant lawyer. But just know they have to have really good cause for not renewing it, and there's limited circumstances, and more or less the tenant has the right to renew as long as they're in good standing and they pay their rent on a timely basis.
Yes, and if the landlord, sometimes I get a call, the landlord said, I want to sell my investment property. And that's the time, the landlord can sell, but cannot renew the lease. The tenant sometimes ask, if my lease ends August 1st, the owner want to sell. And we have the case now, the lease ends July 15th, and the landlord want to put a house on the market now. So basically, that's, we have to let the new owner be aware the lease is protected. So you either close before the date, if you can close anytime, buyer's ready, but they have to honor the lease.
Absolutely.
So we have to let the tenant know in writing, and we entered in contract, this is what happening, and then they have to sign a lease addendum or new lease to the end of the term. So, or we can wait till the tenant to move out, because now it's COVID, a lot of buyer worry about whether the tenant going to move out. So we can close after tenant moved out. So the property can be delivered vacant. Yes.
Right. That happens all the time. Oftentimes, investor A sells to investor B. The tenant is in place. And then basically the investor B, the new purchaser, assumes all the rights and responsibilities as a landlord. The security deposit is transferred to investor B.
At the closing, yes.
At the closing. And then whatever rent is due for the month of the closing is prorated based on the closing date. And then investor B would send a letter to the tenant saying, hey, I'm the new owner of the property. Please from this month forward, send all the rent payments to me at this address. And they would... That's right.
I think a lot of time, right, it's really good thing if you know the current tenant especially is a good tenant, pay on time, very easy to work with, and very reasonable. That's like you're funding a diamond, right? It's free for the new owner. That's really, otherwise you purchase the investment property, you have to be vacant until you find a tenant. Most cases you hire a professional like ourselves, the realtor, you have to pay a month commission and plus vacancy rate. It's all cost. And then you have unknown what kind of tenant you're going to get. But this is proven a good tenant and everything's great. You can collect income the day of your closing. I think that's good for both ends. So most cases, I think the concern is the buyer is going to be self-occupied. That's the time. Sometimes they may not want to close, and they would rather wait till the tenant move out. So they know they're definitely going to move out. Otherwise, there may be a problem for them.
Absolutely, yes. Right. Another case, let's flip it over to the tenant perspective. There are certain cases when the tenant can legally break the lease early. Normally, the lease is a contract between the landlord and the tenant, and it obligates the tenant to pay monthly rent for the specified period of time, typically a year or longer. However, in New Jersey, there's a few specific things they outline where the tenant can get out of the lease early, one of which would be the death of the tenant or the spouse. Under those circumstances, they'd have to give this certain notice to the landlord. I think it's like 40 days, and they would have to, and then the termination would take effect, 40 days after the landlord receives the notice. Yeah. Another case would be if there's an illness or accident that renders the tenant unable to work in a meaningful way. They have to have, obviously, proof of that. They'd have to show proof of loss of income. Yeah. And they'd have to show that whatever pension or savings they have is not enough to pay the rent. They would also need a letter from the physician saying they can no longer work in a meaningful way.
Yes.
So, that's an unfortunate case. But you can see the law is, there's some sense to it because they obviously don't want to create, if there's a hardship, there's a true hardship, death or disability created, the law has statutes in place to protect people from those unfortunate circumstances.
Absolutely. But based on my personal experience, sometimes if a tenant get a job transfer to out of state, right, it really depends on negotiation between them and the landlord. Some tenant will rather settle amount for the remaining. Some won't. So that's really depends. My understanding is if you sign a lease, if you get job transfer, you still responsible until the lease ends. Say if your lease end August 31st, now is April, so you still own all this time until
But the landlord has an obligation to make a good faith effort to rent the place, and then your responsibility would end because the landlord, once they get a new tenant. And oftentimes with the job transfers, those things are often, as with a lot of things, are settled voluntarily, where the tenant will give notice to the landlord, they'll agree on a certain penalty and basically have something that says, okay, I'll pay 2 months rent and we'll just agree the lease is hereby terminated
regardless you rent it out or rent out or not, or rent out as owners.
Or sometimes what happens is the tenants are aware that this could happen during the term of the year term of the lease. So up front in the addendum, they'll put in, hey, we can break the lease early, provided we give you 60-day notice and show you the job transfer letter from the employer. So that sometimes they catch it up front and it's already in the addendum, the buyout provision to get out of the lease early.
We did have an experience because there was one tenant, their visa need to be extended, but nobody knows in today's world whether they're going to be extended, not expanded, they have to go overseas or not. So they put in addendum in such case, they have to leave the country and then the lease can be ended. So that's that once again, if you know the circumstances, talk to the landlord, get agreement and put them in writing.
Absolutely. Yeah. Now, continuing on breaking the lease, again, that's in a sidebar note. That's just a case where the lease may be broken voluntarily, but that's not a legal ground for for breaking the lease, a job transfer. But again, it can be worked out. It can be agreed voluntarily or put in the lease as a provision. Another ground would be if you're over 62 and you have to go to assisted living or assisted care, or you have due to a disability, then you would need something from the attending physician basically saying you no longer can live, you need assisted living. If you have that documentation, you give the proper notice, you can get out.
Yeah, we did had a case, there was a tenant lost his job, and it's a very sad story, and they could not longer afford. So they notify us, we notify landlord immediately, but he was so kind and worked with us. So he moved out as soon as he could move back to home. So, but luckily through his corporation, we can secure another tenant, move in pretty quickly. So at the end, landlord didn't even charge anything. Landlord said, you know what, you lost your job. I'm sorry for that. So if it's only a little bit, a few weeks, a few days actually difference, and especially the tenant did all he could to help us with the showing, secure the next one. So the landlord let it off. So, yeah.
And then continuing on, there's also something for the military. If the person had signed the lease before entering the military and subsequently they joined the military, if they're called on duty, they can, and that makes sense too, if you're called to serve your country on active duty, you can get out of the lease if you give the landlord a 30-day notice with no further monetary responsibility, which is, this is built into the law. It makes sense that would be an allowable way to break the lease. All right, why don't we take a short break and we'll continue right after this. Okay, welcome back. Let's continue on with the grounds when a tenant can legally break the lease. Another ground would be what's the fancy term, it's called constructive eviction. That's basically a fancy way for saying that the place is not habitable because maybe there's no heat, there's no hot water. The landlord has to be given a reasonable amount of time, as we discussed, to fix that, to repair anything. But if the reasonable amount of time has elapsed and there's still nothing done, and the tenant, they can just basically pack up and just say, hey, I'm breaking this lease. I can't live here. There's no hot water. There's no heat. It's been, more than a reasonable time. That's a grounds for breaking the lease.
Yeah, based on that, it never happened to us, so I can't imagine, how there must be a period of time that both sides try to work it out. I would highly recommend the tenant or the landlord get in touch with their agent. So even though some agent after the lease signed, they feel the month's commission is just for the funder fee. Once it's found, the tenant is found, move in, that's it. But other agent like ourselves is very responsible. So we will help to facilitate. And so far, we have never experienced
right.
that.
Thankfully,
so,
right.
Yeah, because anytime tenant have anything, we will definitely talk to our client and give them our advice. If anything wrong in the property, truly improving the property is the landlord's, job to make sure you have to reinvest in your property, right? You buy a new car. But you don't just buy a car and keep driving it. You have to change oil. You have to change tires.
Right.
You have to do things. So does investment property. So after many years, they maybe the window need to be changed or replaced. The ACs, the hot water, and all these things, even the faucet, right? They should be updated from time to time, but has to be reasonable. I did have,
right, and actually we have to jump in here. We actually have landlords that are highly proactive. We have one landlord in particular that basically begged the tenant, said, please, before you move in, I want it for my own sake, because they view their investment properties as pieces of art, as work. So he said, please let me paint the moldings, because he bothered him that there was like little smudge marks. And
that landlord was so funny, right? They own multiple properties. 1 year, they had a tenant want to move in, they signed everything. There was 3 days or 5 days before the lease start, and he was going to use that time to paint, but the tenant said, can I have the key? We already had fire inspections, everything done. I said, sure, absolutely. The landlord said, I said, don't worry about it. Prepaid it only 3 days or 5 days. I said, don't worry about it. These landlords very kind, no problem. So on a day they walked through, the landlord actually had the crew there going to repaint the unit. And tenant said, no, please, this is good enough. I really need to move in. Landlord said, no, I have to paint it. At the end, I said to landlord, why don't you send a crew to my house, paint my house?
Yeah, there you go. You see, that's a case where the landlord is basically arguing and for his own, he's pleading with the tenant, please, let me improve your property before
we'll be quick, 2 days. I said, the tenant said, no, thank you, I'm good. Right. So I said, landlord, but they're already here. I said, why don't you send to my house? They said, no. I said, okay. Right. That was really case by case, but sometimes has to be reasonable. I did had a few times the tenant didn't like the dishwasher, or they didn't like the fridge. They want a new one. They just say something broke. I did had a very, very rare, but once the tenant moved in, first thing they said, the stove is not very good. So the landlord replaced the stove. And then they said, oh, my dishwasher is not good. So the landlord, this only within 2-3 months, replace the dishwasher. And then they start talking about fridge and the wash and dry. To the end, the landlord said, you know what, I'm going to charge you $100 per each item per the lease.
But
and then that was stopped.
But on that same topic, with that same landlord who wanted to paint before the tenant moved in, we had another case, another one of his units. His wife looked at the stove, and there was nothing wrong with the stove. It was like a year or two old, but had a few scratches on it. And then I said, no, the tenant is fine with the stove. It works. It's functional. It has a few nicks on it. But the wife convinced the husband, said, no, it bothered her. So they ended up putting a new stove in, which was, again, they went above and beyond what even the tenant asked them to do.
I can tell you one thing, Ken, right? When this kind of landlord, right, my experience with them is, the tenant always stay longer. Right. The tenant always happy, and then when the next time they leave, move on with their life, they always find the tenant immediately almost. So they always get a good one because the unit is so good. The condition is so excellent, and they always attract the good. I think this universe out there, they attract the good people.
There's a lot to be said. I think keeping your units in good condition and making them desirable and livable makes them rent out quicker. You get a very good clientele because people want to be comfortable. They want to feel that the unit is nice. So if you put the added upkeep into the unit and keep the appliances and everything in good working order, you're going to get the benefit in the long run from attracting a good long-term tenant. Yes. So that's just, and it's kind of a win-win. So you won't have to worry about a lot of these issues because by being proactive, they'll just disappear.
Yes, I mean a lot of time. Once again, the both sides have to be reasonable. Sometimes if both sides reasonable, the relationship is good and the unit is being protected and tenant will take good care of it. That's really just basic human relation here.
Right, and that's what it all comes down to. As we said on prior shows, basically everybody's human, and the best thing is to communicate. A lot of this stuff we cover is the law, but any court will tell you, or any judge, or any mediator, or any attorney will tell you, if you can settle it between yourselves and not have a conflict or avoid the conflict, it's like what's the best way to win a fight? Just to walk away and avoid it. So if you can avoid going to the court or getting involved with lawyers, you're basically best if you guys can be reasonable and decent to each other, and you'll solve. If you can solve it on your own, you're way ahead of the game.
That's right. What's the best way to win the argument? Don't have an argument in the first place, right? So let's talk about the if you do have a dispute, go to court, and what's the penalty to the landlord if the judge disagree with you?
Well, I mean, if you're talking about the security deposit, we covered that.
Not the security. Just say if you move out, the landlord paint the house, say the lease is 2 years. It's happened to us. The lease is 2 years. And the landlord painted the whole beautiful unit before the tenant moved in. And when the tenant was there, they put there was marks on the wall, stickers everywhere, on the window, on the ceiling, and everything, and the scratch everywhere. The floor was scratched, and the landlord obviously is very upset, and they want tenant to pay to repaint and to repair the floor, repair everything. By the way, the floor wasn't have a big hole, or the wall wasn't have a big hole, just the scratches, just wasn't taken care of.
That's really hard without seeing the unit. Everything is a case by case basis. That gets the case basically because the law is basically what's reasonable wear and tear.
Yes.
And that's really very fact specific. You'd have to see the extent of the wall damage. I mean, they're allowed in normal wear and tear just because there's scratches and there's scuff marks on the floor that may not necessarily arise to beyond normal wear and tear. So really,
Ken, what is normal? Say, for example, right, when Maria was young, I mean, only once she put a little mark on the wall, I already disciplined her. So she never really did any damage. Our house painted 10 years ago still look very good, condition. But sometimes, just like a car, right? Your car always clean and neat.
Right.
It doesn't matter how long. My car brand
Your car,
new.
I would get lost in. I can't even find my way out of it. Luckily, if I can get in it, I don't know if I can get out of it. But
I throw everything in my car, the photo, everything. What about anything I found in the property? Because I sometimes, when I see our listing, if I see the paper on the driveway, or if anything I see, I just open the door and just throw in my car. So that's why I have a lot of stuff in my car. But just say, right, it's really from different point of view. The reason I brought it up is for the landlord, right? From your perspective, if your house paint 2 years like a brand new, but this is, used a little bit, in their opinion, is abused, but the court may view differently. So when you go to court to show there's a scratch, there's a writing on the wall, there's stickers everywhere, the floor, because the tenant didn't wear the shoes or something, scratched, or they had a table and chair, they didn't put a protective mat underneath, so scratched. When you go to court, right, I mean, it does mean judge will agree with you.
Oh, that's right, exactly.
So that's why when you do that, when you go to the court, and if you lose, and there's a heavy penalty now to the landlord.
Oh, right. If you wrongfully withhold the security deposit damage, it can be up to 3 times the amount that's wrongfully withheld.
Yes,
that's right. And we had that happen to a client from Bridgewater who had a case in where he withheld. Basically, the tenant did some minimal damage to the kitchen floor. He said, "Well, I've got to replace the whole entire floor to match it." And the court determined, again, every case is fact specific, but in that case, the judge determined you're entitled to the 3 square feet or whatever the damage area is. You're entitled to that value of the flooring, but you're not entitled to the whole cost of the floor reimbursed.
Yeah, but from the landlord point of view, right? And if you put a new floor down, especially the laminate, the automatic click one, when you take 3 square feet out, if the tenant drops something, burn it, you take that 3 square feet out, the whole floor has to be replaced. First of all, you're not going to find the same color, same thing from a year ago. Sometimes it is discontinued item. Even there is, it's very hard to fix the laminate floor because they'll tongue and groove, they just clicked. So very hard. So most time you have to replace at least the area. But the court look at differently.
Right. Well, I'm not saying every court does, but I'm saying that's why you have judges and you have different judges. You have different views and there's different decisions. And that's why you have a court, you have an appeals court, you have the Supreme Court, and even amongst the judges, you have dissent. But again, your example, the floor example, is very case specific.
Yes.
In this particular case, I know that based on what the client experience was, he spent over a week in the court hearing the judge listen to all the testimony, saw the photos, and then the ruling of the judge was very favorable for the tenant and limited the damages to exactly the extent of what was actually physically damaged in terms of the square footage. So, for example, if the kitchen floor might have been, let's say, 100 square feet, 3 square feet was damaged, so the landlord got reimbursed the cost for replacing 3 square feet of the new floor tile.
But it's really not worth the time and energy wasted, for that. So that's the point. And talk to each other. And I always say to my client, there's not really right or wrong. Whether you think it's a business cost, is it worth your time and effort to do that? Court should be like a hospital, right? It's for the emergency. It's for really more important matter. If you're really not sure, I mean, like this case, right? I mean, we did tell them, you may not get everything, but they still emotion take good part of it. So just calm down, just try to work it out.
Absolutely. That's always the best case.
Yes.
When emotions get involved, people out of spite want to do something and there's no guarantee. Even the courts will tell you may be disappointed in the ruling.
Yeah, now it's a penalty to the landlord if that happens. So be cautious, and if you can avoid it, and just settle between yourself. So I think that's more,
Yep. Well, and with that, I think settlement is always the best. Unfortunately, we're out of time again. So join us next week. We're going to start a new topic.
Yep. That's have a great weekend. We'll talk to you next week.
Bye now.